Happy Friday, everyone. I am really excited today because we're going to talk about one of my favorite topics, and that's estate planning. And I'm here with Sandra Schildgen from Wilson and Wilson. She is a partner
Hi.
with this firm, and I'm really excited you're here. So
Well,
thank
I
you.
I'm actually excited to be here too. Thank you for the invitation. I love trying to help out and provide information so folks can be, well informed as to what's out there, and dispel some misconceptions.
That's great. It's so important. So let's just get an overview of what is estate planning.
So, estate planning is far more than I think most people realize. I have lots of clients call in, and all they're wondering about is potentially a will or a trust. And it is so far more inclusive than that. Obviously, will and trust are a big portion of what an estate plan entails, but there's other things to also think about. Beneficiary designations on, IRAs, as well as life insurance policies, annuities. There's how do you have your accounts titled? Are they solely owned? Are they joint? So there, it is far more inclusive than just a will and a trust because it's very little. It's not common knowledge rather, that whatever is designated in a beneficiary designation, whoever is that beneficiary, it doesn't matter what you say in your will or trust. The beneficiary designation form controls, and it is catches people by surprise. Similarly, joint accounts, they pass to the surviving person. Your will can say something completely different, but if it's in a joint ownership, it goes to the surviving person or persons.
That's interesting.
Yeah,
So
and it
you have a
catches.
joint checking account with somebody
Mhm.
and X person dies, doesn't matter what it says in the will. Is
No,
that what
ma'am.
you're saying?
That
Wow.
is exact, and it catches folks by surprise. Oftentimes, a lot of our clients are elder, and you have one child who is taking care of everything. And for convenience purposes, oftentimes, you will see the child who is taking care of everything jointly held, and then, oh, everything's supposed to be equal. My will says so, or that's what I want to happen. And at death, everyone's quite surprised that that is not how it legally goes. Now, the fortunate thing about it is that in most of the families, the joint owner knew it was supposed to be split and shares. And there's a lot of good people out there. That's another thing I want to just point out. Lots of, TV, movies, and such. You see all these, issues. It in reality, a lot of people do get along and love each other and share. So, but we don't want to. I don't know.
You don't want to tempt fate.
Yeah, we don't want to tempt fate. I guess is the best way
Right.
of saying it.
And there are things that are just tax ramifications that have nothing to do with, the family members, but there are tax considerations.
There are some tax considerations with respect to that. For instance, if you are legally the owner but then want to share, does that mean now you're gifting from your estate? Do you have taxable estate issues? I mean, it's a good problem to be over 4 million. And
Right.
not everyone is going to have that issue, but it can create that issue. And, folks who are fortunate enough to have, over the $4 million exemption mark in Illinois. But aside from just kind of what happens at death, there is the other part that most of us don't think about with respect to estate planning. And that is what happens when you're incapacitated. Incapacity is going to lead you into a guardianship court proceeding. And part of an estate plan is also avoiding that. Powers of attorney for property, powers of attorney for health care, and to some degree, if there's a trust assets can be managed by a trustee if the person who set up the trust becomes incapacitated. And that all avoids having to march into court in a very public way, asking for mom or dad to be declared by a judge legally incapacitated, and having to account every year to that judge to what you've done with literally every single penny.
Yes.
So powers of attorney, I know it's estate planning, and we think about death and how to leave our legacy to our loved ones, but it's also a very big component of what it happens at incapacity, leaving those advance directives in place, including things like living wills, whether you want to be disconnected from life-sustaining treatment, and who can have access to your medical records and things like that. So estate planning, back to your original question, is far broader than I think most of us may think. And it is essentially, and succinctly put, an instruction manual for your family. What to do if I'm incapacitated, what to do at my death, who gets what, the timing of it too is also important as to who gets what when. Yeah.
And I think for the powers of attorney, that it can be, it's not just because somebody is dying. Somebody could get, be in a skiing accident and just be knocked out, and
Yes.
So it's not like you think, well, I'm not sick and nothing's going to happen to me, but it's something that you could be incapacitated for 5 hours or something.
It could be, with respect to that, the question that often comes up, it's like, well, I'm young, or I don't have a lot in my estate, but nonetheless, you have something. You have a bank account, you have bills to pay, you may have credit cards that need to be paid, and so you need someone with authority to transact for you, whether it's an incapacity that you are able to work back from and regain your capacity, or if you can't. And it's recommended that anyone over 18 have a power of attorney. Horror story, we had a person returning from college, got into an accident. He survived, but was left with some significant issues. And so now he's in a guardianship for the rest of his life. If there had been powers of attorney in place, whoever was the agent under the power of attorney could have transacted for him in every way, including the personal injury case that occurred and from where he received some assets. And so it's hard to think of our college-age kids, and I have one that's just past that, to need powers of attorney in case something happens. And in case something happens also, and I think I bring this up, a lot of folks don't want powers of attorney because they feel that someone's going to take advantage, or look into their health care or make health care decisions in a way that they really don't want. There can be restrictions as to when they trigger. So a power of attorney could essentially stay dormant unless there is a doctor's note indicating that there is an incapacity of some sort. And if you are really not trusting of the world, you can have it be 2 doctors, or a doctor and a loved one. It can be customized, because that's what an agency is. You're giving someone authority to do something, and you can say when that authority starts.
That's interesting. That's a very good point. So, it's not like you're knocked out for an hour and somebody comes in and runs your whole life.
Swoops. Yeah. And there are things in place at financial institutions. They're not just going to, oh, your power of attorney and you say so. They're going to look at that stuff. They're going to want a copy. If the doctor's note is required, they're going to require that.
Right.
There's certifications that it's still in place that the agent may have to sign. There's a lot to it. It's not just a free-for-all to get at your assets,
Right. And what happens? What happens if you die and you don't have a will?
Well,
Or is
if
that
you,
a really big question?
it is a big question because this actually can be a seamless predicament or one that really puts you into a bad predicament. So it is commonly thought that if you don't have a will, that the state will take your assets. That is not the case. I hope that I can rest people assured of that. There is a statute that essentially has some defaults. And the defaults, and I'll only go a few deep, is, spouse, if there's only a spouse, if there's spouse and children, spouse, kids. If there's none of those, and parents and the siblings in equal shares down to the nieces and nephews. And it keeps going, but that's usually as far as we get. And it is something that if you don't have a will, the state of Illinois has essentially made a will for you.
Okay.
The issues that can occur with that is if, let's say, you have a spouse and children, well, if your children are minors, now you have guardianships for the minors because a minor cannot receive money directly in that way. If you have minors and you had a guardianship, at 18, they get all of the assets that you receive. Now, that may be that it wasn't too much and it was spent during the kid's lifetime. Okay, but if it's significant, you now have an 18-year-old with a ton of money that they receive directly immediately upon, attaining age 18. And so what the estate planning helps do, whether it's through a trust or a will, is to hold those assets for minor children or young adults, because 18-year-old is an adult. Usually about age 22, 25, we're holding in trust for the children. And we do so that someone, like, if both parents have died, like a trusted aunt or friend or someone, it could be a bank as well, or a professional trustee, can manage the money, pay for things that the child needs, health, education, maintenance, and support-wise. So you can pay for college, you can pay for the apartment, you can pay for the food. And then once the child has reached a certain age and presumably some level of maturity with age, then you're starting to, distribute whether it's the whole amount or fractions. So a third at a certain age, half of what's left at another age, and then the remaining, let's say 30, 35. And usually we try to have the distribution dates be, at major points in life, whether it's graduating college or probably maybe looking for a home at this point, maybe have children by this point, that sort of thing. There's other, points that we can also include. But that's essentially what an estate plan does. It carries out your wishes versus what is in the law, which is the default. And there are times where, let's say, if you had someone who maybe it's not the greatest person with money, you want to hold it in trust for them. Or perhaps they need public aid, whether it's, SSI or Medicaid or something of that nature, so that they're able to keep that eligibility. Because if they're receiving assets directly, there are some solutions, but you have to be a certain age and so on and so forth. And you also have to have the person be willing to also do that planning. Whereas if you leave it in further trust, you can protect eligibility because things like trusts such as supplemental needs trusts are exempt for public aid benefits.
So yes, so if you have money in a special needs trust and that money can sit there and that would be exempt and you would still could, if you meet all the other criteria,
Of course,
receive public assistance. So I don't know if we have time to get into all of this right now, but maybe in preparation for our next conversation, Many of the seniors that I talk to, they are getting ready to sell their home.
Mm-hmm.
They are getting ready to move into some kind of a senior community
Mm-hmm.
and have no idea what the tax ramification of that is, what they should do with their money, where should they put it? And then again, what is their plan if they have to spend down to be eligible for a Medicaid or supportive living situation?
Right. With estate planning, there often is sort of the 2000 level planning that comes along with it. With asset protection, if someone's going into, say, a nursing home or an assisted living that takes the Medicaid long-term care program, you have to be quite careful with that. There is, of course, the 5-year rule, and there are certain types of irrevocable trusts that can be put together where you sock that money away and don't expect to be able to use it. And that's where you're asset protecting. Go ahead.
Well, I was going to say what I'm hearing and what we're often faced is that seniors need to consult. And what I tell them to do is I always say, please talk to your estate planner. If you don't have one, I'll get you one, because this is more complicated than just, oh, the community will help me figure it out. Because in my gut, and I'm only speaking from my intuition, by the time you get to that community and they're figuring it out, there could be a lot of things that were not handled correctly.
Right. And part of the, I guess, it's not an issue, but part of, I guess, the circumstance is that, the communities can't practice law.
Right.
And if there are assets that a person has, they're, obviously under no obligation to tell you what you can do planning wise to maybe preserve some of that. So I don't necessarily blame them. It kind of is what it is.
Right.
What we try to do as elder law attorneys is, convert what is allowed by the statutes, because it's all, written in either federal, state, or administrative, code, of the items that you can move over and convert that asset from being available to pay for care to something that Medicaid itself allows you to keep.
Right.
And there's plenty that they don't allow you to keep, but there is plenty that they do allow you to keep. And some of it, is a little bit of awkward planning, putting money aside and not using it for 5 years. That's going to be difficult.
Right.
But
And 5 years is a long time. You can't start when it's too late.
Exactly. And normally one would proceed in that way if there is maybe long-term care insurance that's going to kind of cover the gap, or if it's a recent diagnosis and we suspect we know where this is leading, it's going to lead to, being in a skilled nursing facility or assisted living at the very least in the next 5 to 7 years. So it's not planning that, you do every day. And of course, you have to be able to have access to sufficient assets while you're in that 5-year, wait time. So it's not for everyone. There's other types of planning that can be done at the doorstep of a nursing home admission. But though, that's a very complex conversation, but there are solutions. And, Medicaid has recently changed its stance on leaning real estate as well. They're not leaning real estate anymore during life. They'll be making their claims in probate when the person passes away. And the probate proceeding, just to sort of come back to that, is when you have a will or if you don't have a will. And the only assets that the will controls are assets that are in your sole name. If they're in trust, the will doesn't control them. If they have beneficiary designations, the will doesn't control them. If they're jointly owned, the will doesn't control them. So part of the planning in an estate plan is also to not leave assets that are in a sole name, so that potentially you can, you don't have that avenue for some sort of claim for any benefits.
Okay.
So.
All right. When we're going to talk about that in greater depth, because that
Another
is
time, yeah.
another time, because that's really for my audience. That's a special. Not that everyone isn't my audience, but for the senior audience, it's really important. And I always tell them, I say, please see an estate planner sooner than later, because we can sell your house, we can find you somewhere to go, but it's a little more complicated. Somebody that really is trained and is a lawyer that can practice law needs to sort of set you straight, give you your recipe, and then we can go out and find the particulars.
Right. And one of the main goals of when you're mixing Medicaid planning with estate planning is that we are trying to protect anyone who is a minor or under 21, not really a minor, under 21. And we've had some sad cases where someone had a stroke and they had young children. Not that any of them aren't sad, but you know what I mean. Particularly sad when it's a young child who's affected by someone having a stroke. So we've had young children, we've had siblings who can be protected to some extent. Spouses receive the lion's share of protection, and disabled children. So if you have a child who is disabled, they're able to receive your home. They're able to receive every cent you have before Medicaid makes you spend it. Now you have to do it correctly, but and that is something that can happen during life through a power of attorney without having to go to court to ask to do that. And so that's
very,
bringing it full
very
circle.
Interesting too, because I have a case where something, a client where something, and I said to them, you need to go see you need to go see an estate planner. And some things you just said to me, I think they really need to go see an estate planner. So I will make that phone call. But this has been really, really helpful, very helpful. And I think number one, plan, because things are complicated, and it makes it even more complicated if you start doing things that cannot be undone or need to get undone. So,
or you leave yourself with the inability to get them done without court intervention.
Right. And that makes it even more complicated, and it's more expensive, and it drags it out and on and on and on. So, bottom line, see your estate planner and plan. So, Sandra, I want to thank you so much. This was great.
Well, thank you.
I want to have you back to talk about some other things in depth.
Sure. I'd be very glad to. Well, thank you very much for having me. And, I welcome the opportunity to chat again.
That's great. And if anybody wants Sandra's information, they can reach out to me. It's Wilson & Wilson. You're located in Northbrook, and, we'll get you the information.
All right. Well, thank you so
everybody
much.
Have a great weekend. Thank you so much.
All right. Bye-bye.
Thanks. Bye-bye.